going to go ahead and address the elephant in the room. Yes, my name is Darth. My God-given name, I was not named after Star Wars, but for the purposes of this presentation, my introduction to technology happened a long time ago in a galaxy far, far away. Out of college, I actually started my career as a business technology consultant with a company called Accenture in New York City. Accenture taught me how to code, they taught me how to do systems design and IT architecture, they taught me about project management. And when I first got to Accenture, I thought I was going to be this guy. I thought I was going to be Neo in the Matrix, that my Kung Fu code is better than your Kung Fu code. I found out relatively quickly it was actually this guy, okay? I understood the technology, and I understood how to apply it, but what I thought mistakenly was that I could not compete with men and women who I thought were born to code, that had some innate talent or some ability. I was very good at project management. I was very good at explaining to the clients how the technology applied. I was good at getting clients to want what we wanted them to want. So after a long discussion, a bit of a debate with the technology executive in the telecom industry, he jokingly said, maybe you should go to law school. Seemed like a good idea at the time. It was a joke, but I went ahead and went to law school on the West Coast. And like many of you, it was the paper chase. Socratic method, being told you're going to need to know this to practice law. We were given law books, we reverse engineered the law to figure out the elements. And then at the end of the course, we were given the option to take our exam with a pen and a blue book or a computer. Now this is directly kind of opposed to MBA programs or even my Master's of Real Estate Development, where I could not take my finance course if I did not understand Excel. If I didn't understand Microsoft Word, I could not participate in the group projects. So here I am, graduating from law school, this lawyerist, so excited to be going into the legal industry. I assumed this billion-dollar industry that's built largely on data, taking data, synthesizing it, regurgitating it, analyzing it, that basically builds 6 minutes at a time, would be on the leading edge of technological innovation. Let's just say after my first day, I was a little frustrated. All right? I found that most lawyers looked at technology kind of like it was magic. Indeed, Arthur C. Clarke's third law. Okay? And I'm embarrassed to say that the first time I saw this quote is actually during the practice of law. I had a case in the Central District of California, and we beat their case 3 times on the pleadings. And the judge gave opposing counsel one final time to amend their pleadings. Gave them 10 days, issued notice electronically. 10 days comes, goes, no amended pleadings. We ask for dismissal. Prejudice is granted. This was the quote opposing counsel made, saying basically, look, I don't know why I didn't receive the email. It must be magic. The court did not find that credible. Oddly enough, he also found some way to blame me for it, but the court didn't buy that argument. Because we know email's not magic, okay? And around the same time, the model rules were changing. And as many of you know, our duty of competency, model rule 1.1, has been amended in about 2012 to add to it a duty of technological competency. We have to understand the benefits and risks of relevant technology to our practice. And now 27 states have codified this within their own state bar associations. And states like my home state of California have implemented it through legal precedent and opinions. And our neighbors to the north are considering implementing this as well. Florida's taken it one step further. Florida's the first state to require its attorneys to actually devote CLE time to technological training. But it won't be the last for long, because technology is deeply integrated into what we do, okay? You take the most senior attorney in whatever firm that says, hey, look, all I need is this legal pad, this pen, and these law books, and I'm able to practice law. It's simply not true. Let the internet go up for a day, and he's going to freak out just like everybody else. We have to use technology to communicate with our clients, to communicate with opposing counsel, indeed, to even communicate with the courts. It's part and parcel to what we do, and we're being held accountable for it. Sanctions, malpractice. So when you get a case and you're not competent, you've got 3 choices. You can decline that representation, you can sufficiently learn the subject matter before you undertake it, or you can associate or consult with technological consultants or with competent counsel, okay? Decline, learn, associate, or consult. Those are your only options. But I submit to you today that many law firms are taking the easy way out when it comes to technological training. They think they're hitting an easy button. And that easy button is simply, we're going to hire young people. We've got a generation of people that were born using technology. They don't know a time where the internet didn't exist, where they didn't have a little computer that fit in their pocket. Indeed, they're on these devices all day, every day. In fact, what percentage of millennials do you think sleep with their phone? 83%. And this was a few years ago. It's probably higher now. But that stands in stark contrast to the percentage of millennials that actually have tech-savvy skills to solve problems. Growing up with the technology doesn't necessarily mean you're tech-savvy. And this is where we come into bias. This positive stereotyping. And it's a problem because it leads us to implement faulty strategies when it comes to technological training. We look at our kids. They're using technology at a young age. We think they're geniuses. Oh, my daughter can use an iPad. There's genius there, but the genius is for an Apple engineer to create a device so intuitive that a child can use it. There's a digital native narrative going on there out that somehow technological skill sets are innate. They're a talent. The same thing I thought those coders had when I was at Accenture. And it's a myth. And it's a myth that we need to dispense with. Look, just because you can microwave a Hot Pocket doesn't mean you can cook a gourmet meal. Just because baby boomers had access to cell phones and cameras didn't make them any more technologically savvy. And just because those things have now been put into a device that fit in your pocket doesn't mean you can use technology to produce complex work, which is what we do as lawyers. Okay? Millennials, for a large part, are consuming technological content. They're not using it to produce technological work or complex work product. And let's be honest, as a society, we're all pretty bad at technology. Only about 5% of well-developed rich countries have a population that can use technology in any high and competent way. And only about a third of people can use it to do medium tasks. And if you look at this chart, which is pretty busy, it basically says we're all pretty bad at technology. We need to change the model, especially in law school. We need to go from a model that says, hey, you're going to need to know this to practice law, to you're going to need to know how to do this to practice law. We need to give our young lawyers a skill set, a toolbox. And in that toolbox needs to be, I'm sorry to say, skill sets with basic office technology. When you talk to recent graduates, they actually rank basic office technology as one of the top 10 things you're going to need to become a lawyer. It ranks higher than legal reasoning, and I think that's crazy. I also think it's leading for young lawyers to be extremely unhappy. You go to law school because you want to be a problem solver, right? You want to be Tom Cruise, you can't handle the truth, and then you're put in front of a machine for 15 hours a day that you've never actually been taught how to use. And you end up doing tasks that are extremely boring and mundane. And you're starting to see talent leave the industry. See, what our clients want and what they want to pay us for is our advocacy and counsel. And that's in large part what most of us went to law school to do, to become lawyers, to become problem solvers. We end up spending a lot of our time on the production of content, on the production of work product. And that's what our clients are pushing back in terms of paying. When you look at demand over the last 10 years, except for the Great Recession, it's remained pretty constant in the legal industry. But in stark contrast, is the realization rates have been dropping every year for the last 10 years because our clients are no longer willing to pay for the production and content of work that is, quite honestly, very inefficient. The legal industry is actually increasing, but in-house departments are growing. They're taking the bulk of that work, and they're pushing it away from outside counsel. So what do? We double our efforts. We work harder. We work longer. But doubling your efforts does not make up for a lack of skill. Inherent in that comment 8, in your duty of competency, is not just the risks that you'll be sanctioned if you don't understand technology. You have to understand the benefits of technology and how to apply that to producing work product. I'll give you an example. You take a lease, commercial lease, 100 pages. We've got one version where an individual doesn't really understand how to use the innate functionality of Microsoft Word. We've got the second lease, where you have an individual who understands the functionality of Microsoft Word. If we were to insert a provision in each of these leases, it would require us to basically update 273 cross-references, 136 sections, and that's 409 opportunities for error. Okay, 409 opportunities for malpractice, and a lot of work. And if you have to do that manually, it takes about 2 hours and 26 minutes, and it's boring, and we don't want to do it. At least one uses simple, like Word, like it's a glowing typewriter. It doesn't understand the innate functionality. At least two uses styles and functions. So those 136 sections are automatically updated. At least one does not use cross-referencing. At least two uses cross-referencing. So it's the difference between taking 2 hours to do something manually and updating something instantaneously. And that's what your clients are tired of paying for. And this brings us to another duty regarding our fees, Rules 1.5. We're not able to charge an unreasonable fee. We have to consider the time and labor required, and we've got to do it in a cost-effective manner. Word, we test a number of lawyers on this, and we've got 12 easy tasks here. You know what the average score is on this? It's only 50%. Lawyers are only about able to do half of it. And this is their response every time we test them. Well, I don't do that. My secretary does that. Our response is simple. What secretaries? We let them all go. We blame technology on it. We don't need them anymore. That's what we said. And we tested secretaries. We tested law students. We tested lawyers. Guess how they played out? Lawyers actually perform better than law students, and they perform better than their secretaries. And they're doing more and more work. Mitch Kowalski, he's the visiting professor of legal innovation in Calgary. He gave our test to all of his students. Only 1 out of 15 passed. The rest of them failed. This was using basic office technology. This is why this is one of the biggest falsehoods on any resume. I'm proficient in Microsoft Office. It's a falsehood, not a lie, because we don't know what we don't know. Word is not a single-purpose app. It's an ecosystem of apps. It has deep, deep functionality. But how many lawyers have ever actually clicked on any of these buttons? How many lawyers have been taught actually how to use this program? And it's ubiquitous. It's installed on about 98% of all laptop systems. Availability, simply making training availability, doesn't equal learning. Why? Because we don't know what we don't know. When we don't know what we don't know, we're extremely confident in what we do, okay? I'm ignorant that I lack a skill set, so I have this delusion of adequacy. So I do not explore the fact that I lack this skill set. If we break that ignorance, you're like me in coding. I don't know what I don't know, but I know I don't know enough, okay? That's the only way we can get lawyers to the point that they're experts in this. Learning takes time, and we're busy, busy people, okay? We've got deadlines to meet. We've got billable hours to make up. We've got business development. And we do not have time to sit in a traditional lecture-style learning environment. Time is a poor proxy for learning. Okay, simply sitting there and listening to someone like me talk is a poor proxy on whether you actually understand the content that's being introduced, especially if you're already familiar with some of that content. So we need to change the model. The model needs to move from lecture-style model in teaching to competency-based education. Okay? Competency-based education is really simple. It's education based on a core set of competencies verified in a skill set. We take the traditional training model and we flip it. Instead of I lecture, you learn, you test, you learn by doing. We create an environment, an assessment, where you're initially tested, a legal technology assessment. And the reason we do this, we test you up front, is two reasons. One, we don't want to waste your time training you on things you already know. So you tell a lawyer, hey, look, you're going to take a test. That sounds like a horrible idea. Tell a lawyer, hey, look, if you take this test, you get to test out of mandatory training later. Sounds like a splendid idea. So you give them task-based assessments. And you give them a real-world environment. Here you have updates to a contract. Delete the comments. If you do it right, you never see that task again. The learning loop is closed. You move on to the next thing. You do it wrong, however, you stay in the learning loop until you actually get it right. It's adaptive, active, and synchronous in learning. And the first part of that assessment there is to validate the need that you need to learn this task because you don't know it. And once you do, we're able to verify it. So for every dollar you spend in getting a new gadget, a new toy, you need to spend tenfold on training and process improvement because we have the tools, but we don't know how to use them. This is a chart talking about the accelerated growth in technology. It's exponential. And about, the half-life for a learned skill used to be about 30 years, which means if you graduated in 1955 and you didn't update your skill set, by about 1985, the world had passed you by. Now it's 5 years. And in real time, that's what this looks like. This is a speech given at the Vatican by the Pope, 2005. Same speech in 2013. The world is changing exponentially. We have to invest in process and training as much, if not more, than the technology. A failure to do so means we will never actually be able to adequately serve our clients. Lawyers have the tools, but we don't know yet whether they know how to use them. We don't have transparency and accountability. We're going to need that moving forward. It's in the best interest of the industry, and we owe it to our clients. It's our duty. Thank you.